Hey, good afternoon, everyone. In Introduction to Law, I thought I'd put up a quick review for Chapter 11, which is estates and probate. This time it will be relatively short. The book is very, very good. It's a chapter that I think is well written, and I don't think it needs a lot of additional commentary from me. But I do think Chapter 11 is important with estates and probate and wills because it tends to overlap with a lot of other areas that we get to deal with. And you should know the basics of estates and probates. Of probate of estates. So going through the chapter, might as well talk about what probate is. When someone passes away, they have an estate. Everybody has an estate, maybe just debts, but everyone has some kind of an estate with some assets or negative assets we call debts, and it needs to be dealt with. And it needs to be dealt with to ensure integrity, that the person's assets and debts are appropriately distributed in case of assets, and debts are appropriately paid out of the assets of the estate, if any. And the court, basically the probate process, the probate court, administers the estate through either we call it an administrator or an executor, one's with a will, one's without. Although you can have an administrator with a will if the executor dies or is not willing to do it, who is named in a will. Get to that in a second. But the point is there's somebody that basically puts forward a decedent's estate into the probate process, and we try to make sure the assets go where the deceased wanted them to go, or if they were silent, meaning they died without a will, we want to make sure that the statutory scheme, there's sort of a rubric or a plan that's put into place, and we make sure the assets go where the law requires. A lot of people think if you die without a will, your stuff's going to go to the state or the government. Very, very rare. Usually we can find someone related by blood or marriage to allow the decedent's estate to go to. Most people die without a will. I'll get to that in a second. So why don't we talk about what is a valid will? In Massachusetts, a valid will is a written will. It has to be in writing, has to be signed by the testator, the one having the will written for them or writing it themselves. Then it has to be signed by two disinterested witnesses. What's a disinterested witness? Someone who's not going to receive any gift or share under the will, as well as anybody who would receive something if the person had died without a will. That's an interested witness. We want somebody who has no stake in the game to sign. And they should be adults as well. The law is not quite clear on that. You really want not only the testator to be 18 years of age or older, of sound mind, knowing what they're writing is their last will and testament, which is basically the distribution of their assets, and that's the legal function it'll have. And then you want two witnesses, not necessarily knowing what is in the content of the will, but that the person who wrote the will did it freely, voluntarily, looked as though they were of sound mind. They say who they were, and they signed it freely and voluntarily, and looks like they were under no duress or mental limitation at the time of signing it, or directing someone to sign on behalf in case they're incapacitated. That is usually done all in each other's presence, and those witnesses then acknowledge the testator's signature. Now, a lot of people think you have to have a notary to notarize the signatures on the will. I'd like to say for practical purposes, you should treat it as if it's a requirement, but it is not. You can have a fully valid will signed by the testator and two disinterested witnesses. For example, I write up a will today, I type it up, I ask two of my neighbors to come over. They're not going to receive anything under the will, and they wouldn't have received anything if I had died without a will. They're all over the age of 18. I'm over the age of 18. I'm competent. I don't look like I'm under any kind of duress, delusion, or fear, and I apparently know the document that I've written is my last will and testament. I've identified it as such to my two neighbors. My two neighbors are over the age of 18, and they're competent to watch me go through that signature process, the scribing, and they witness as well. They sign it. That is a valid will at that juncture. Now, the notary, the reason why it's so important and why I want you to treat it for practical purposes as a necessity, it's a lot easier to prove the validity of a will and the signatures on it as that of the testator and that as of two disinterested witnesses if a notary was there to acknowledge. It gives a certain level of, it's called the self-proving affidavit. It just does that. It self-proves the witnesses were in fact there. It did in fact sign in the presence of the testator. And it also proves that the testator signed in front of the notary, who is authorized basically to attest and ascribe to witnessing someone's signature to a document, thereby giving it that much more credibility in terms of being voluntarily and freely executed. So you want to have a notary. You really do. It makes it a much easier process in the probate of the estate. Now, one thing I want to warn you about, we're only talking about probate assets. If you own a joint bank account, let me just grab my coffee here. If you own a joint account with your spouse or your kids and you die, that does not go through probate. It goes to the person who jointly owns it with you. Same with real estate. If I own my house here with my wife as tenancy by the entirety or joint tenancy, and I die or she dies, the survivor of the two will automatically own it. It does not go through probate. And a lot of people don't want to go through probate because it stalls the process by which time the decedent leaves us and their assets get title placed in their loved ones or their heirs' possession and ownership. Because you have to go through the probate process, and it's a little time consuming in the court of law, although we have a speedier process now called involuntary administration of an estate. It's or informal, I should say, not involuntary, informal. It's a fairly quick process, but still it's a process. And so a lot of people want to avoid probate. Well, some of the methodologies by which you avoid probate are doing payable on death clauses on your life insurance, payable on death clauses on your retirement accounts, payable on death, which is called an état account on a bank account. They don't necessarily have access to it, but they receive the right to it upon the death. All they have to produce is a death certificate. And they own other property jointly. And by owning it jointly with the right of survivorship, they avoid probate, and the other person gets immediate access and control over it. There could be tax consequences in estate planning. Taxes only come into play on the federal level if it's a little over $12 million in the estate. And in Massachusetts, it's a graduated tax, and it starts at $1 million. Those joint assets might be part of the taxable estate of the decedent, but the transferring of title is automatic by a payable on death clause, life insurance, things of that nature, 401ks, retirement plans. One of the critical issues is that most people will die without a will. So what happens? A lot of people think, well, my stuff's going to go. I don't even have a will. I used to write wills as part of my law practice at one time. So I don't have a will. If I die, what's going to happen to my assets? Oh, it's going to go to the state. Oh, no, it's going to be terrible. Well, no, it's not. It's actually, there's a scheme involved where they look at kindredship and guilt. Basically, do you have a spouse? And I do. So they would look first to my spouse and give usually a fairly significant lump sum. I believe right now the current law in Massachusetts, the first $250,000. And I believe after that it's 50% of the rest of the estate. That's part of my probate. That wasn't payable on death automatically to other people. For example, I own some real estate with my brother and my sister, and we own it jointly. That's not going to go to my wife or my kids. It'll go to my brother or sister should they survive me, because it's a joint ownership with right of survivorship. It's a very powerful tool, but it's also not necessarily what maybe somebody wants. Maybe I want that real estate or my share of that real estate to go to my children. So we got to be able to identify what's in the probate estate. So if I die without a will, you look to see if there's a spouse, because they'll get a significant portion. If there's a remaining portion, then it gets divvied up between the spouse and children. If there's a spouse and no children, there may be grandchildren. So you always look to the right, see if there's a spouse. If no spouse, you look down to kids, grandkids, great-grandkids. If none there, then you would send up. Maybe I still have parents alive or grandparents alive. And then if none there, then you look out laterally to brothers and sisters, cousins, aunts, uncles. There's a whole chart of lineage that we use in a estate planning practice to determine where assets are going to go to when it gets a little complicated. But if there's a spouse and kids, I think it's fairly easy to divide the probate estate. It has to be probate, though. If it's payable on death, if it's one of those kinds of mechanisms or jointly owned, it's not part of the probate estate. So going through the intestate succession, usually most states have, including Massachusetts, something called per stirpes. Basically, we look, say my wife predeceases me, and now they look, do I have children? Yeah, I have 4 children. And so basically, the 4 children will take equal shares of that. My brother will get nothing. My sister will get nothing, because they're the first line of kindredship under the chart. Now, what if I had 4 kids, but one of my kids predeceased me, but she or he had 2 children of their own? In most states, when it comes to children, siblings receiving, and they predecease you, their children will receive by right of representation. And it's all set up in the statute. It's fairly easy to read through. And if you're not doing this regularly, I don't do this anymore at all. But if I did, it would take me 20 minutes, 30 minutes or so just to catch up on the different intestate succession charts that we have when someone dies without a will. Doesn't mean they get it immediately. What do we have to do? We have to take out a probate of an estate. You literally fill out some forms at the probate court, bring a copy of the death certificate. And why are you filing it? You have to show that you have standing to be the administrator of that estate of someone who died intestate without a will. If they died with a will, you still follow almost nearly the same procedure now, which is filing as an executor or an administrator with a will attached. And basically, they're synonymous for the most part, the administrator and the executor. What they're trying to do is they're basically marshaling the assets of the decedent because they have some standing. They're a relative, a loved one, or potentially an heir under the will, or they were named in the will to be the administrator of the estate, which we call an executor. They file the documents in probate. What do? They garner all the assets. They make sure the last medical expenses of the last illness were paid for. They make sure the burial expenses are paid for out of the decedent's estate. And then they hold all the assets together, and then they get permission from the court to distribute them as the will requested, if the will should be deemed to be valid, or if there's no will, through the intestate succession process. Maybe there's people, maybe I'd say I had to die and I owe my law partner $100,000 on a loan I took out. He'd be a creditor. And so if I died and say made my brother my executor, he'd gather all my assets that are in my probate estate, not my life insurance policy that went to my wife, that goes outside of the probate process. But everything that's in my probate process would be gathered. Creditors would be paid first, including the primary ones, the last medical bills for my last illness, and then my burial and funeral expenses come next, and then debtors, like my law partner, for example. If I did owe him $100,000, he'd make a claim, he'd file it in the probate court, and they would distribute funds to all the just creditors. If there was enough money to go around, all of them would be paid. If there wasn't enough money, then it'd be prorated. It's kind of common sense. After the creditors are paid and there's more assets left, then it's distributed to the heirs at law. And the heirs at law are spouses and children. And again, no spouse, no children. Then you go to grandchildren, no grandchildren, great-grandchildren, none of those. And you look up the parents and grandparents, again, none of those. And you go out the siblings, and then further out the cousins and aunts and uncles and all the rest. That's intestate succession. And you should know the difference between per capita and per stirpes. I think every state has per stirpes, from what I understand. And that's basically distribution based upon being in that class of heirs. So first class is spouse, next, there's only one spouse, but then next is children. And then after children is grandchildren. And then once you find that level where the first surviving entity is, then you distribute per stirpes. And you can give right of representation if there's offspring of those immediate relatives. Per capita is you just find out all the different relatives that survived me that are in the chart, and they each get an equal share. It's disfavored. It's kind of unequitable, really. What I always find when I used to write wills, most people, when they write their wills out, sometimes they leave 100% to their spouse. Then they say, but if their spouse predeceases them, then distribute equally among my children, which is pretty much what intestate succession does anyway. So people usually aren't that surprised about it. Yeah, I'm just going through the requirements of a valid will. Again, don't do a video will, don't do an oral will, don't do a handwritten will. You want it typed, you want it signed by the testator in the presence of two independent witnesses. And again, what's an independent disinterested witness? Someone that doesn't receive under the will, nor would they have received if there was no will. And then you want it notary. And the notary has to be there as well, witnessing both the testator, the person who's going to write the will or have it written for them, and the two witnesses all in each other's company. Wills, codicils, and revocation. Wills are called ambulatory, meaning they can be revoked at any time. I can write a will right now at 10 o'clock in the morning, and I get upset at one of my kids, and I can tear it up, and because I don't want a big share of something I gave to that child anymore, and I can revoke it. I can write as many wills as my computer or my lawyer can spit them out in the ambulatory. They can be changed at any time. You can write new ones if you want, and if you write a new one, the one most recently written would be the valid will. However, if I have a will sitting in front of me right now and I'm disgusted by something that's in it, and I tear it up, and that's a revocation. By tearing it up, now my estate will go through intestate succession until I write a new valid will, if ever. Never have copies. If you do have copies, make sure they're stamped as copies. The confusion with that is sometimes people write. I have a friend that wrote multiple wills. I'd write them for him. He would tell me his wishes, and he was changing it every few years. My fear is, I said, "What'd you do with the old will?" He goes, "It's somewhere on my desk." I'm like, "Well, what if he's actually a fairly organized guy, but what if he was like me? I'm very disorganized. You go through my desk, you might find 4 or 5 different wills. Well, what if you don't find the most recent? The court will probably enforce the one that's latter. So you always want to destroy old wills, and you only want to keep one original will. And if you have copies, mark copies, they cannot usually be probated. There's some special rules for probating a copy of a will, but then there's all kinds of evidentiary rules to establish that that is the last will and testament, the desire. That's what the goal is. The probate court is trying to make sure the desires of the decedent with a will is honored. And so the will has to have clarity, it has to have focus, and the person writing it has to be, again, 18 years or older, of sound mind. And that's pretty much it. And it has to be in written form. Don't do a video will. I've heard stories about that. I've watched movies where someone does a video will. And somebody said, well, I'll do a written will, but I want to do a video will just to kind of, leave my sentiments behind and let my family know how much I love them and all that kind of stuff. The problem with that is if there's anything inconsistent with the video and the requests in the will, there might be an argument that the video might have been made after the written will, and is that acting as a revocation of something that was in the will? Otherwise, you just don't want those kind of inconsistencies. If you want to send out a video about how much you loved everyone and why you're still well, and you can articulate those things, do that, but don't do anything about distributing the assets in a video will. It'll have no legal effect other than maybe potentially challenging the legitimacy of the current written will you have. Codicil is basically an addition to the will. That's kind of become passe. We don't do that too much anymore. So you might have like a 4 or 5 page will, all these different, I've got different, I got a coin collection, I have some hunting collections, I've got political button collection, I got these different things I collect, and jewelry, things like that. I might want different kids to get different things because I think they have an interest in them, just trying to be, make them happy at the end. Well, what might happen along the way is I might say, geez, I've come into some new things. I'll add a codicil. A codicil is an editing of a previous will. It could revoke things in the will, could modify it, or could just add things to it. One of the reasons why it's fallen into disfavor, it can cause confusion. Because is it revoking that previous part in the will that relates to this, or is it just adding to it? Is it clarifying something? And the reason why codicils were once very popular, someone would write a will in the old typewriter fashion, and it would just be some new added aspect of it. It'd be easier just to add the one page. Today's modern world, we usually keep software, word processing, Word documents, Google documents, whatever. We keep them as drafts, and it's much more easy just to edit the whole will so we have clarity and consistency throughout and just write a new will, because a codicil has to have all the same requirements as a valid will, signed by the testator in written form, 2 independent disinterested witnesses, and preferably also notarized. If you're going to go through all those same steps, you're basically writing a will to add to another will. Much better off writing a whole new will to avoid confusion. If someone wants me to do a codicil, not that I do these anymore, but if I did, I wouldn't do it. It's not that much more effort to write a whole new will, especially if I was the one that wrote the original will. I'll keep in an electronic form their previous writings. It's much easier to edit that, in my opinion, in going forward. Revocations, anything that shows the testator's intent to get rid of the will, destroying it, throwing it, crossing out, burning it, or writing a new will. That in and of itself destroys the old will. Burdens of proof. Yeah, this is clear and convincing. If someone's challenging the validity of a will, it's not just that they have to prove by a preponderance of the evidence that it was entered under fraud or material mistake of fact or duress. They have to prove by clear and convincing evidence those events happened. So it's a very heavy burden on the challenger. Otherwise, people would be so motivated by money, they would challenge wills all the time. I watched a few will contests and trial because they tend to be very fascinating. We go through the process in probate. They allowed certain things. Oh, what if somebody writes a will and disinherits their spouse, husband, wife, that whatever you want to call them, a spouse, and you give everything to your friend, and you're legally married at the time, and the spouse is stunned, and they come into my office and says, "Geez, Jim, my spouse has died. They left everything to some charitable organization, the Red Cross." And I'm going to be impoverished as a result as well. It doesn't matter if you're going to be impoverished or not, because as a spouse, that's one individual you can't disinherit. So that spouse can take what's called an elective share, sometimes called a forced share, because they literally force the estate to give them a portion. I believe in Massachusetts is 1/3 of the estate, which is oftentimes what people want to give their spouse, and the rest usually is the rest and remainder go to children. Sometimes you give 100% to your spouse, and then upon the second of you dying, it's just two wills. A lot of people say, "Oh, I want a joint will." We don't do joint wills in Massachusetts. I think some jurisdictions did or might still do that. Big mistake. You don't want to do that. You have two wills, and I'll say everything to my wife if she survives me. But if she doesn't survive me, then to my children, share and share alike. My wife will have a similar will. Everything to my husband if he survives me, but if he doesn't survive me, everything to our children, share and share alike. Another reason why you might want to have a will, my family is the perfect situation. I have 3 stepchildren. I have 4 kids of my own, and then my wife has 3 kids, and if I have a previous marriage, and so those are my stepchildren. If I die without a will, my wife will take a significant portion of my estate, but then my 4 kids will take the other. What about the other 3 kids? Somebody's laughing or saying, well, they're stepkids, they shouldn't get anything. Well, what if the stepkids have been in my life for a long time and I've grown very close to them, I'm fond of them, and I'd like to see them have something? They'll get nothing unless I have a will. Very important to have a will. Same with people. People aren't getting married as much anymore. Right? Some of you are in family law. Marriage rates are down significantly. Some people say, well, the divorce rates are down too. That's because no one's getting married anymore. But people that still have significant others that they care about. You're with somebody for 20, 30, 40 years, and you might want all of your things to go, or a significant portion of your estate to go to that loved one, but you didn't get around to writing a will. You can't go to court and say, this person's been the love of my life for the last 50 years, and I should get their estate, and you don't. You need a will. That's why wills are important in that regard. Another reason why I think it's good, very important to have a will. If you have minor children, you can name a selected guardian. You should always ask the guardian ahead of time of the person that you're proposing as a guardian if they'd be willing to do so, because guardianships can be rejected. But you ask some loved ones, siblings, whatever, hey, if I pass away, I want you to raise, your nephews and nieces or whatever it is while they're under the age of 18. That's actually valid, and the court will uphold that unless there's compelling reason not to do so. That's provided the other biological parent of the children is not available or unwilling to take care of the kids. So if I died, left all my 4 kids are older now, but say they were, they're kids, they're like 5, 6, 7, 8, 9, 4, whatever their ages are, but they're all young kids. And I put in my will, I leave the guardianship of my 4 children to my sister, Patricia. And if she fails to serve as a guardianship to my 4 children, my 4 minor children, I name my brother Joseph as guardian of my 4 children. That would work, provided that their mom, who's still alive, didn't come forward and say, wait a minute, I'm the biological mom and I'm fit and I'm ready to take over there. There's no guardianship issue here. So people sometimes try to do that. I've had that happen. People say, well, I want my sister to raise my kids if I should die. And I'm like, okay, you want your sister to be guardian? And I can't help myself. So what would happen to the father of children? He goes, oh, he's across town. I can't stand him. I'm like, well, if he's fit, you can't disinherit his right to raise his child as the biological father, provided he's fit. But you can still put it in there because maybe he'll still predecease you or something like that. Or maybe he won't basically exercise his rights. Sometimes people don't. So for share, that's the big thing. I'm just going to read the review questions, see if I've missed anything. I think it's per stirpes, one over that per capita, valid will in writing by the testator over the age of 18, sound mind, in the presence of 2 disinterested witnesses, preferably notarized. What grounds can a will be tested? All the classic ones, well, they were mentally incompetent to write a will. The other more classic ones, that's less so because of the signatures on the will tend to obviate the competency issue. But the ones that come up, there's fraud, duress, material mistake of fact. Those are the kinds of things that come into play. Major steps in probate estate, basically you file forms and get a death certificate. And if they have a will, you probate with a will. If they don't have a will, there's a probate of estate without a will. And you sometimes have to file a bond to make sure you're basically acting as a fiduciary on behalf of the decedent. If anything goes wrong, you promise to make that estate whole if you should squander money and things like that. And again, the term estate, these are only things that the decedent owned at the time of their death that do not automatically transfer to significant others from payable on death clauses, like insurance policies. A lot of people own real estate by tenancy by entirety because they're spouses, or like my brother and sister and I, we own some real estate jointly. which automatically inures to the benefit of a survivor if any of us were to die. Oh, who can be disinterested in the will? I said a wife or a husband cannot be, or a spouse cannot be, but children can be. You can put in your will, I have 4 children, or I'll say 7 because I count my stepchildren, and I do not give any. You have to name them though. That's really important. You have to say, I do not give my son, Jonathan Corman, any money, any estate, any share whatsoever upon my death. That sounds very cruel, but sometimes people want to disinherit certain relatives because of a falling out, or sometimes it's actually for a more happy reason. Maybe my son Jonathan, I don't have a son Jonathan, I'm just using that as an example. My son Jonathan turns out to be a great orthopedic physician, and he teaches at Harvard Medical School, and he's a multimillionaire, and he's also won the lottery, and he's got more money than he knows what to do with. And I have 6 other kids that are struggling financially. So when I used to write wills, I'd have occasionally a case like that when someone says, well, I've got 4 children, but I don't want to give anything to this one. And I'd always feel appalled because the way my father was and stuff, you love your kids unconditionally and all that kind of stuff. So I say, well, why aren't we giving anything in a case? And that's what usually would come up. So they're very, very successful. My other kids are kind of, having a tough road to hoe, and I'd rather see that. I said, let's put that in the will. You can put things in the will like that. To my daughter, Mary, I don't leave any material assets. All I leave her is my love and goodwill, and all the best memories ever, because Mary has been a great success. And that's the only reason, and for no other reason, why I divested her from any monetary interest, something to that effect. And I think that's a beautiful sentiment, because you don't want people to be embittered. The other thing, too, is if you have a very large estate and you're disinheriting somebody, and that somebody is not that wealthy, they may challenge the validity of the will because they feel they're entitled. There's no entitlement, but they feel that they're entitled to something. So they're going to say, dad or mom was really incompetent, or signed this will under fraud, duress, or trickery, or without true intent. And so sometimes you do a gift where you say in the gift that if this person challenges the will, the gift that I've given him in the will, let's say you're a multimillionaire. I leave Jonathan, $300,000. But if Jonathan should challenge this will or contest this will any way, shape, or form, he will lose and forfeit the $300,000 grant that I've given him in this will. By doing that, it's a way of dissuading people from potentially challenging the will. It's one of the tools that estate planners use. Who determines the inheritance of a person charged with murdering the testator? That's called the Slayer statute in Massachusetts. We have it in every state, I think. It's only for intentional first-degree murder or second-degree murder. Manslaughter doesn't count. So if I'm out, not me, the client's out drinking and driving with their significant other, they kill their spouse in a tragic car accident, and they were drinking and driving, they're charged with motor vehicle homicide. I do not believe that applies in Massachusetts. They'll still be able to inherit from that spouse. It usually relates to first or second degree murder, which is the intentional taking of another person's life. They are not allowed to inherit, and that kind of makes sense. Where does this stuff go? Well, we just basically treat them as they predeceased the decedent who was murdered, and the rest of the estate travels through the will, if there is a will, and if no will, through that intestate succession scheme that we have. And we don't have oral wills. I'm not going to spend any time on that last question. The chapter is pretty straightforward for the most part. I like it. And there's a whole separate class at the Mount. It depends on what semester, who's teaching it, but it's usually Judge Goldstein from right over in Gardner District Court. He used to write a lot of wills himself. I don't know which book he uses, but estate planning can be a valuable course because it gets into real nitty-gritties of all the different ways you can own real estate. So it overlaps a great deal with that. And then it actually go through some model wills, how they're written and how they're introduced, and the different clauses you want to put in there. Because if you're not careful, wills can get kind of gummed up. Like if you say, first, I want all my last just debts paid for out of my estate. Second, I want my house to go to Mary Jane. Well, what if you want the house to go to Mary Jane, but there's an existing mortgage on the house? Your first clause said you want all your just due debts paid first. Now the mortgage will be paid off and Mary will get that house free and clear. Well, then you wanted another kid to get $250,000, but maybe because you had all the debts paid off, there's no more cash left, and Mary ends up with this $500,000 home, and Johnny doesn't get anything because you said that clause. So you got to be very thoughtful when you're granting these different gifts. And the other is about specificity, specific gifts, like I leave my Corvette to my son Jack. Say it's worth $50,000. It's an old, 67 Corvette with the fastback thing on it and everything. It's really nice. And during the process, I'm like, well, Jack's never going to want that Corvette, so I'll sell it. And I'll even put the money, the $50,000 in an envelope, and say, money from the sale of the Corvette. And then when the will comes along, it says, oh, Dad left me his 1967 Corvette. Well, the Corvette gift is extinguished because I sold it. And even though there's cash in an envelope that says from the sale of the Corvette, he does not get that cash. That cash will be distributed by how the will has determined that part of the assets to be distributed. It might be through what's called a residual clause, where it says, the remainder of my estate shall be divvied up between the following people. He still might get a piece of the pie, but he's not going to get the piece that was once that Corvette. So sometimes people do things like that. They say specific, this house, this antique chair, these cufflinks. You say specific things like that, and you sold them before you die. Those gifts are extinguished, and it frustrates people sometimes on the will when they know that it's been translated into cash or some other asset. It's gone for purposes of inheritance, directly. Well, that's a pretty good summary, I hope. Hope everyone's doing well, and don't ever be afraid to reach out and ask questions or raise concerns.